6713, we are required to disclose. But then that is a rule that is known to all and practiced by all, and therefore it is incumbent on the person concerned to follow that, because non-observance of the rules can expose you to certain liabilities. As again, I will continue to maintain my previous statement that I will reserve judgment. What I can say is that charges have been hard. He has filed the necessary answer, and that is what is being looked into by the Presidential Anti-Graft Commission as well as the National Bureau of Investigation.
Mr. Chairman, I realize that there is an ongoing investigation by the Presidential Anti-Graft Commission, possibly by the Ombudsman. But within the SEC, there must be that strict observance of the principle of full disclosure, of disclosing potential conflict of interest, of disclosing pecuniary transactions with entities that are being supervised by the SEC. Is that not correct? I'm not asking you to make a judgment on whether a crime was committed, on whether an ethical violation was committed, but I'm focusing right now on the observance of the principle of full disclosure. The question now, did Commissioner Martinez violate that principle by not disclosing that he had transactions within the Los Angeles family, whether by him directly or through his family?
Yes, we have those strict rules of disclosure. All from the officials and employees of the SEC are made aware of this, and this is something that is required of them to be filed. For instance, in addition to the statement of assets and liabilities, there is also a requirement of disclosures on holdings in, let's say, equities.
I'm sorry, I'm not
yes,
talking of the SEC right now. I'm talking of other transactions that are not required to be reported in the SAL, because these are two different things, Madam Chairman.
May I just be allowed?
Those equities are going to be reported in the SAL, but I'm talking of, for example, if you buy something from someone whose corporation is being supervised by the SEC, that is not going to be reported in the SAL, but in my opinion, that should be reported in observance of the principle of full disclosure. Now, whether there was an ethical violation or not would be determined later. But in my opinion, that should be disclosed. Would you not agree with this, Madam Chair?
It should have been disclosed if he is convinced that he is doing. I mean, that's why I would not like to make a judgment. But as to whether we are strictly enforcing that, everybody knows about the requirements of 3019 as well as 6713. And therefore, it is incumbent on the official or employee concerned to observe these rules. Failing which, then he can be held responsible.
In this case, I was talking about Commissioner Martinez. Now, Madam Chair, I'm sorry to mention this, but the chairman herself was mentioned that the spouse of the chairman may have had a financial transaction with Mr. De Los Angeles. Is that not correct?
Mr. Chairman, I'm glad that has been mentioned, because in all the forums where that issue has been raised, actually it has not been raised officially. It has been raised in the media, and immediately I gave the following answers. On the first question, there was a request on the basis of documents furnished by, nobody now wants to admit who is the source of that document. Even Senator Rojas says that, well, he does not know who gave him the document, he just saw it on his files. It is a claim for reimbursement of a practicing lawyer, not my husband, for a luncheon bill, where he invited my husband, according to this claim, and Mr. De Los Angeles to lunch at the Mandarin. And this was June of 2004, when my husband was a practicing lawyer how was he still with the Bangko Sentral of Pilipinas. Of course, when it was made known to me, I inquired from my husband, have you ever met him? Or was he ever your client? And he denied it. So that was the answer that I gave to the media. The other transaction is regarding a Pajero, and this is what I would like to point out. There was a document shown, again, nobody wants to admit how these documents are faced, as part of the internal documents of the Legacy Consolidated or whatever, the group of Mr. De Los Angeles. And it says there, it was a claim for reimbursement of registration expenses for a car previously assigned to Attorney Alejandro Barin. And I said, how can that car be previously assigned to Attorney Barin and be registered in 2007 when we had owned that car? And I have all the documents in my possession since 2001. We bought it. Even the documents from whom we bought it were preserved because we had it transferred in our name. So, and then another claim saying that that document, the registration was for a car assigned to Attorney Barin. Now, this shows two things, that you cannot control internal documents that were own entries. I had all the certificates of registration of the car. We were registering it from 2001 to 2007, showing that we owned it, and we were in possession. Yes, it is true that sometime in 2007, it was sold to a certain attorney, Christine Limpin, who happens to be associated with Mr. De Los Angeles. There was an appropriate deed of sale for 500,000 pesos for a 1997 Pajero, which was imported to rebuilt unit from Japan. It was a V6. It was an expensive type of car. And therefore, at that time, 500,000 pesos was a normal cost of the car because some well-meaning friends, when this thing was brought to fore, also showed us some issues that at that time of this sale in 2007, the going rate, depending on the condition of the car of such a Pajero, would be between 360 and 550,000 pesos. So that's what I asked. And the registration was lawfully covered by a deed of sale and by the transfer. It was also transferred, the ownership was transferred to Attorney Christine Limpin. This is all that I can say. But what I want to point out is that it is very dangerous to rely on internal documents which is outside of our control, because those claims are false.